just like many people, we are not taken by surprise that this is the final outcome that came. From the beginning, there's been resistance. And maybe just to take us back, in 2002, a electoral task team was set up to look into this very issue of electoral reforms led by the late Dr. Slavat. And in January of 2003, that report was made public. And these changes that were, the recommendations that were made were supposed to be implemented in 2004, in time for the 2004 election. And lo and behold, there was no enough time, and that matter was put aside. And 20 years later, we are still talking electoral reform. We are still talking the fact that there's not enough time to make implementation of these recommendations that are actually saying this model that we have was transitional. If you'd remember, the reason was that it was known at the time that most of the leaders that were in exile, so people would not know who to vote for. So let's package them into political parties for the first elections. But going forward, that needed to be changed. And we are sitting here 20 years later. And the political parties' bosses like the system. It works for them. And ultimately, the voter just comes to tick off. And once we hand over the mandate, they just, make decisions. And people are not accountable to anyone. So I'm not surprised because there's always been that resistance from the political parties.
Many had actually stated that you would never have seen anything different because they stand to benefit if they were to structure or conceptualize it in such a way as they did. But there was a lot of celebration in the country when that ruling came out from the Concord. And of course, many have said that that which was envisaged and that which is now in the form of the bill are completely different. But not just different, but that this is in fact a step back. Where do you stand on that?
Firstly, yes, there was a lot of rejoicing. I think the thing we must still rejoice over is that ordinary people stood up and they brought out and highlighted an issue that is a problem in the nation. And like I said, it's been more than 20 years when this was left to the ruling party. If it was left to them, nothing at all would have been done. And Nomfundo, you and I would not even be talking about this. South Africans wouldn't even know. For the longest time when the case was in the court system, though it was known that there was a case that could potentially change things, many South Africans didn't even know what this was about. So I think on the one hand, we have to be grateful in that, we've done something as ordinary people to bring an issue like this to the fore. And I think that's one of the things that we have to constantly push and find those loopholes as much as we can take, those who are in positions of power, hold them accountable. But again, it is not what was envisaged. But at the same time, we weren't aware. I mean, I knew that the issue of the reform of the electoral process to get to a place where it will truly be more representative, etc., that even the change of this law alone was not the only solution. So this was part of the many things that must be corrected in order to help increase accountability. So what has been done is really, in a way, it's sort of, how do I put it? It's like, you just agree to something just so that we continue what we are doing at the end of the day. I doubt that independent candidates, candidates will be able to push, through and compete with political parties at the state. I mean, other civil society movements are planning to take this matter further to court. as well, because there's general unhappiness when you understand. And I think that's another thing. People still don't even understand what this thing was about in the first place. There's a lot of education that needs to be done. And that was not done. If you think about 2002 and how long after that report was released, we were not talking about it. Why? It shows
but for
you
those
that,
apologies for interjecting there, but for those that are looking to mount this legal challenge, what are the prospects of success? Because if we go back to the Constitutional Court ruling, there it was said Parliament must remedy the defect. Now, these lawmakers, parliamentarians sat there, one would assume that they made sure to say now independents can participate. And one wonders if the Constitutional Court can be so prescriptive as to say, no, the manner in which they will be participating now defeats the purpose. Or they'll just say, you know what, we gave it to Parliament, they refined it, and the bill has been signed into law, they remedied a defect. Are there prospects of success, really?
Nomfundo, I lost you a little bit there. If you don't mind, just to recap, I missed a bit of what you said. My apologies. I think my network just let me down.
Not a problem. My question is, we understand that there's those now that are looking to petition the court. What are their prospects of success, just on technicalities here? Because the Court had taken this matter back to Parliament to remedy that defect and allow for independents to participate. Can parliamentarians not say, well, now they get to participate, so we have complied?
Unfortunately, at the end of the day, the will of the people is still not really finding expression in this compliance. This compliance is merely compliance for the sake of compliance. One, the delays that were in the process, number one, that's one of the challenges. Number two, now, the very people who came to the court asking for justice are told, we're told, wait a minute, and then you delay. Eventually, when you do agree to remedy the situation, you also delay the implementation, and now you put them under pressure to perform within this. And also, you've not actually, given effect, you've not changed things that would actually materially help the independent candidates to participate. So at the end of the day, where is the justice in this? I found it interesting, even as you're talking, that it was signed into law on the 17th of April, which was exactly the same date that Judge Desai dismissed the case of New Nation Movement back in 2019. And that was April. Elections were coming up in May, and they knew that this case had the possibility of actually altering the way the elections were going to take place. But the delays in the system allowed for elections to be held within this kind of, with the current model that we have. And now, when the judgment finally comes to say, actually, the elections that we held, the Electoral Act is unconstitutional, which meant, had this case been heard on time, we should have made these changes before the elections in 2019. So now we are saying, okay, now we don't have enough time. We will just comply and just make amendments just for the sake of saying we've accommodated you as independent candidates, but we've not given effect to the spirit of the request, and that is to allow participation according to the Constitution to be, to allow individuals to be able to stand. So the way the changes have been made, really, it's just political parties who are saying they own the space, and if you want to come, we'll just give you a little bit, as if they're doing it a favor to people, forgetting that they themselves have been given the mandate by ordinary South Africans. So this whole thing, really, South Africa, it's about ordinary people must recognize the power that we have as voters. If you look at what happened in the Johannesburg Metro, Ekurhuleni, the city of Cape Town, where people vote for a political party, hoping for a particular leadership, and then politicians decide to have caucuses and they change. The next thing, you have leaders that you never voted for. So those are things that are beginning to manifest, and perhaps 20 years ago, we were not matured enough as a democracy to actually understand what does that mean, that we vote for a leadership, a political party under a leadership of a particular person, and then these people decide to just swap. So I think what needs to happen really, there's a lot of, I think there's merit, that, the case can be heard, because this has not given, there's no justice done to the initial request that was taken to.
A very powerful statement you make there, that indeed parliamentarians have complied, but they haven't given effect to the spirit of that request and ultimately the spirit of the Constitution. Tshegofatso, thank you very much for your time.